And if anybody arrives hereafter, they can always jump in at any stage. My name is Conor McCormick. I'm the Deputy Director of the Human Rights Centre in the School of Law at Queen's, as well as being a lecturer here. And it's my pleasure really today to introduce the speaker who has kindly agreed to speak about litigation in Northern Ireland around the Irish language. So we have Tim Jacob-Owens joining us today, who is a doctoral researcher, excuse me, at the European University Institute, as well as being a research assistant with the Global Citizenship Observatory at the Robert Schuman Centre for Advanced Studies. This seminar came about because I listened to Tim give a version of this presentation at this year's SLS conference. So that's the Society of Legal Scholars, which holds an annual conference each year. It's very widely attended by academics, but I thought his presentation was excellent and deserving of a wider audience. So we were really, really pleased when he accepted the invitation extended on behalf of the Human Rights Centre to speak to us today. And I'm delighted to see that so many people have shown an interest by registering and by attending. So as I said, the title of Tim's talk is Litigating Irish Language Rights in Northern Ireland, and I'm confident that you're going to find it both interesting and informative. If you have any questions or comments as we go through, please type them in the chat bar, and I'll pick those up at the end if there's time and channel them over to Tim to see if he wants to reply. Do keep them short if you can. There's a tendency for those things to run far too long to be manageable. Keep your questions and any comments short. And for me, if you wouldn't mind writing them in English, I would really appreciate that, because with apologies, I don't think my GCSE qualification in Irish will be enough to take me through anything beyond the conversational. So that's all I have to say by introduction. I'm really pleased to be making this introduction. So thank you very much, Tim, for coming, and over to you.
Okay, great. Thanks very much on that. Can you hear me all right, just to check that that's working?
Yes, that's working great.
Okay, great. So I'll just share my screen. Okay, and hopefully you can now also see my slides.
Yep.
Okay. Great. Yeah, so thanks so much to Conor and Cheryl for the invitation to present today. It's really a genuine pleasure to have this opportunity to talk about this work with this audience in particular. It really is seems like the ideal forum in which to be discussing this topic, so I'm very grateful. What I'm presenting today is a draft article, as Conor said, on Irish language rights litigation in Northern Ireland. This is currently under review, so there's still time to make changes if it turns out I've got things wrong. I'd welcome any and all feedback that people might have. So the original inspiration for this paper actually came from a trip to Belfast a little over a year ago, back in the time when that was still a thing that we could do. And I went to do interviews for my PhD research, which is on linguistic justice in Europe. And in the PhD, I focused more on the immigration context. But while I was in Belfast, I got the opportunity to also do a couple of interviews with Irish language rights campaigners, which were fascinating in a number of ways, and among other things, drew my attention to the existence of this series of legal cases, judicial review cases, dealing with Irish language rights disputes. And this is the focus of the paper today. And what I'm particularly interested in for the purposes of this paper is the different legal strategies that litigants in these cases have deployed in order to try and assert language rights claims before the courts. So hopefully the slides work. Yeah, okay. So just a little bit of an outline then. I'll start with kind of very brief conceptual background, kind of how I'm framing the cases in the paper and what I'm focusing on more specifically. I'll then give a little bit of contextual background to the legal status of Irish in Northern Ireland. I'm very aware that I'm quite probably the least informed person here about the broader context. So this is, as much as anything else, just to kind of set out where I'm coming from, my understanding of the situation, and just in case there might be one or two people watching who are perhaps less familiar with the Northern Ireland setting. And then the majority of the presentation I'll focus then on the three main legal strategies by which litigants in the cases I'm looking at have attempted to assert language rights claims. So these are claims under, firstly, the European Charter for Regional or Minority Languages, secondly, the European Convention on Human Rights, and thirdly, domestic statutory duties, powers, and the common law. And basically what I'll try and show is that the first two strategies, so attempts to invoke these international sources of law, have been unsuccessful for various reasons, but the third has had some success and has created the scope for language rights litigation in Northern Ireland. Okay, so in political theory, language rights are typically understood as being justice-based moral claims to protection and promotion for a particular language within the public sphere, and generally grounded in some kind of broader claim to equal recognition for a distinct cultural or linguistic group. So this might take the form of the teaching of a particular language in state-funded schools. It could be the use of a language in the delivery of services, or the symbolic recognition of a language in the so-called linguistic landscape, in public signage, and so on. Now, Bruno de Witte has suggested that the development and enforcement of legal protection for minority or minoritized languages in Western Europe has generally come about in response to political rather than legal mobilization. So lobbying, public demonstrations, forms of political advocacy rather than litigation. And this is thought to be especially the case in the UK, because UK language legislation is typically formulated in terms of duties imposed on public authorities rather than as rights conferred on individuals. And on this basis, it has been suggested that the UK therefore lacks what is sometimes referred to as the legal opportunity structure to allow individuals to bring language rights claims before the courts. And in this paper, basically what I'm trying to do is to argue against that view and to show that language rights litigation is in fact possible under UK law. And I do so by reference to a series of 5 judicial review cases dealing with Irish language rights disputes in Northern Ireland. So we have 5 judgments from the High Court in Northern Ireland, and then 2 of these cases were subsequently appealed to the Court of Appeal. Okay, so context then, as I'm sure everyone here is aware, Irish is a Celtic language closely related to Scottish Gaelic, more distantly to Welsh, and was once the principal vernacular spoken across the island of Ireland. Its use was widely suppressed under English rule as part of a kind of broader programme of cultural imperialism, and its vitality is now threatened in various parts of the island. The language played an important role in reasserting Irish national identity following independence, so it was recognised as the sole national language in the 1922 Constitution of the Irish Free State. And today in the Republic of Ireland, it has similarly the status of the sole national language and the first official language. So at least in a kind of fairly superficial, formal sense, it has a privileged legal status there. And again, as I'm sure everyone is well aware, the situation north of the border is rather different. So the Irish language has come to be associated primarily with the Nationalist Republican Catholic community, one of the 2 traditional communities in Northern Ireland. And so the issue of Irish language rights has then come to be bound up with broader contentious issues around cultural and political identity. So the use of Irish in public life in Northern Ireland was at least not encouraged, and in some domains actively prohibited for much of the 20th century. But as part of the peace process in the 1990s, some steps were taken towards recognition and protection for the language. So the Belfast Good Friday Agreement recognises the importance of respect for the language, and it also contains a series of more concrete commitments on the part of the British government concerning its promotion. And the agreement states that these commitments were taken in the context of the active consideration given by the UK at the time to ratification of the European Charter for Regional or Minority Languages. So this is an international treaty that was drafted under the auspices of the Council of Europe in the early 1990s. And the UK went on to ratify the Charter in 2000, recognising Irish as one of its regional or minority languages. Some domestic statutory provision has now been made to permit or promote the use of Irish in public life, but there are a number of areas of ongoing contestation, 4 of which have been raised in legal disputes before the courts in recent years. So these are language planning, court proceedings, schooling, and street signage. I'll talk a little bit about each of these in turn now. So language planning concerns strategic policy making concerning the kind of overall development of a particular language, so in this instance Irish. On the basis of a commitment made under the St Andrews Agreement 2006, the Executive Committee of the Northern Ireland Assembly was placed under a statutory duty via amendment to the Northern Ireland Act 1998 to adopt a strategy on the promotion of Irish. This relevant provision entered into force in 2007, and nearly a decade later, the committee did eventually consider a strategy of this sort, but it failed to garner the requisite cross-community support, and it was never adopted. And this prompted an Irish language rights NGO, Conor na Gaeilge, to apply for successful judicial review in 2017. Another area of legal challenge has been the use of Irish before the courts in Northern Ireland. So this has been prohibited since the introduction under English rule of the Administration of Justice Act 1797, which established an English-only judicial language regime and remains in force to this day. And this was challenged by an Irish-speaking musician who had sought to apply on behalf of a concert venue for an occasional liquor license in Irish. And the Northern Ireland Court Service refused him permission to do so through Irish, and this decision was subsequently upheld by both the High Court and the Court of Appeal. Unlike in the context of judicial proceedings, some statutory provision has been made for the teaching in and of Irish in schools in Northern Ireland. So on the basis of a commitment made under the Belfast Good Friday Agreement, the Department of Education was placed under a statutory duty under Article 89 of the Education Order 1998 to encourage and facilitate the development of Irish medium education. And disputes concerning the provision of Irish medium schooling have been litigated in 2 subsequent cases. So the first of these concerned transport provision for what was then Northern Ireland's only Irish medium secondary school. And campaigners argued that greater provision was required in order to allow pupils from further afield who had gone to Irish medium primary schools to continue their education through Irish at secondary level. The second of these cases, so this is GC's application, concerned the decision of the Education Minister to reject a development proposal which would have allowed an Irish medium primary school in Belfast to relocate to new premises where it was hoped that it would have improved facilities and thereby achieve capital viability. And then the final area of legal challenge has been the issue of Irish language street signs. So under the Local Government Order 1995, local councils in Northern Ireland were given the discretionary power to install bilingual signs in English and any other language, so including Irish. Under the legislation, councils are required to have regard to the views of those living in a street where new signage of this sort is being proposed. A procedure adopted by Belfast City Council for this purpose, which requires a two-thirds majority of local residents to be expressly in favour of a particular proposal, was subject to unsuccessful legal challenge in 2014. And this case was brought after the council rejected a proposal for bilingual English-Irish signage, which, when the council surveyed local residents, had been opposed by just one of them, expressly at least, and had been supported by around 60% of the residents, who had nonetheless then failed to quite meet the 2/3 threshold. Okay, so with that background to the cases in mind, then I'll turn to the first of the legal strategies that litigants in these cases have employed in an effort to assert their Irish language rights. So this is claims under the European Charter for Regional or Minority Languages. In the case concerning court proceedings, it was argued that the ongoing prohibition of the use of Irish before the courts in Northern Ireland was incompatible with the UK's international obligations under Article 7.2 of the Charter, which provides for the elimination of any unjustified restrictions on the use of regional or minority languages. And this interpretation is supported by the Committee of Experts on the Charter. So this is the independent Council of Europe monitoring body, which is responsible for state compliance. And the committee had expressly stated that the prohibition on the use of Irish in court in Northern Ireland by the 1737 Act, so this is the Administration of Justice Act 1737, is an unjustified restriction relating to the use of Irish, and therefore incompatible with Article 7.2 of the Charter. So as a matter of international law then, this claim seems well-founded. However, before the domestic court, it had very little traction, thanks to the well-established principle in the UK of constitutional dualism. So as an unincorporated international treaty, the Charter is of course not directly enforceable in domestic law. Now the applicant tried to circumvent this in two ways. So firstly, arguing that ratification had nonetheless given rise to a legitimate expectation that public authorities would act in compliance with the treaty obligations, and secondly, deploying canons of statutory interpretation to suggest that Parliament should be presumed to have legislated in compliance with the treaty obligations. The High Court rejected both of these arguments. So it found that in light of the principle of constitutional dualism, the legitimate expectation would actually be the opposite. So we would expect that unincorporated international treaties would not be enforceable. And it also found that the terms of the 1737 Act are clear and unambiguous, and essentially to any kind of change to the judicial language regime would require legislative reform and not simply creative statutory interpretation. So the overall question then of a possible breach of Article 7.2 of the Charter was deemed to be non-justiciable. Another claim under the Charter was made in the case concerning street signs. So here it was argued that Belfast City Council's procedure for installing bilingual signage was incompatible with Article 10.2 of the Charter, which provides for the use or adoption of traditional and correct forms of place names in regional or minority languages. Again, this argument came up against the sort of insurmountable hurdle of constitutional dualism. So the High Court essentially reiterated the finding from the previous case. The Charter, as an unincorporated international treaty, is not enforceable, so the matter is non-justiciable. So these two judgments together then demonstrate that ratification of the Charter, while clearly politically significant, especially in the context of the Belfast Good Friday Agreement, has not created the scope for domestic language rights litigation in the UK. So I'll turn now to the second strategy employed by litigants in these cases. So this is claims under the European Convention on Human Rights. And of course, claims of this sort don't have the same barrier of constitutional dualism, thanks to the incorporation of the ECHR into UK law via the Human Rights Act 1998. As we'll see, on the other hand, the claims have faced problems of a different sort. So again, in the case concerning court proceedings, the applicant argued that the prohibition on the use of Irish before the courts violated his rights under Article 6 of the Convention on the Right to a Fair Trial, taken together with the prohibition on discrimination under Article 14. And the High Court rejected this argument as well. So it found that because the applicant was also fluent in English, his not being allowed to choose to speak or write in Irish before the court had no bearing on procedural fairness, and his Article 6 rights were therefore not engaged. This seems consistent with the case law of the convention organs, which have repeatedly held that Article 6 does not entail a right to use the language of one's choice before the courts. And I've quoted here the decision of the European Commission on Human Rights in Zara against Turkey, where it held that a member of a linguistic minority may not complain that they are not entitled to use their own language before courts in which the language used is that of the majority. The same argument was subsequently rejected also by the Northern Ireland Court of Appeal, but for different reasons. So as I mentioned before, the case was brought by an Irish-speaking musician who had tried to apply on behalf of a concert venue for an occasional liquor license. And the Court of Appeal found that because he was not actually employed by the venue in question, he could not be considered a victim within the meaning of Section 7 of the Human Rights Act, and therefore lacked standing. And the court further held that even if he had standing, the English-only sort of monolingual judicial language regime in a jurisdiction where English is the language of the majority was necessary and proportionate in a democratic society and could therefore justify any potential discrimination that the regime might create. And the court also reiterated the view that any change to this regime would require legislative reform. Now, there are certain aspects of this decision that seem somewhat insensitive to the very particular historical circumstances of the Irish-speaking community in Northern Ireland. But it's hard to see that this decision could have been, or the case could have been decided any differently by the European Court of Human Rights, which has found analogous areas of language policy, such as the choice of the working language of a national legislature, to fall within states' margin of appreciation. Human rights arguments have also been unsuccessfully deployed in the context of schooling. So in GC's application, it was argued that the decision of the education minister not to allow an Irish medium primary school to relocate to new improved premises violated the rights of a child at that school under Article 8 of the Convention. So this is on the right to private life. And this argument was readily dismissed by both the High Court and the Court of Appeal, and this again seems unsurprising in light of the case law of the European Court of Human Rights. So the Strasbourg Court, had found in its well-known Belgian linguistics judgment that Article 8 in no way guarantees the right to be educated in the language of one's parents by the public authorities or with their aid. So again, as with the Article 6 claim in the previous case, we can see that the kind of language rights claim that was being here simply fell outside the scope of this provision of the Convention. Another attempt to invoke the ECHR was made in the other case concerning schooling. So here it was argued that the Department of Education's decision not to expand transport provision for Northern Ireland's only Irish medium secondary school impeded the exercise of the right to education under Article 2 of the First Additional Protocol, taken together with the prohibition on discrimination under Article 14. Now, again, there was an issue of standing here. So the case was brought by the vice chair of the school's board of governors, who was not herself, of course, a pupil at the school, or the parent of a pupil at the school. And the High Court found that there was therefore considerable force to the view that she could not, for this reason, be considered a victim within the meaning of Section 7 of the Human Rights Act. In the end, the court declined to rule definitively either way on the human rights argument, but it seems difficult to see how this could have succeeded even if there had been standing. So the court, again, the Strasbourg Court, in its Belgian linguistics judgment, had found that Article 2 of the First Additional Protocol, taken together with Article 14, does not have the effect of guaranteeing to a child or to their parent the right to obtain instruction in a language of their choice. Now, as people may well be aware, the court did find one aspect of the Belgian school language regime to be discriminatory. But what appears to have been decisive for the court here was that this was about differential access to education in the two national languages, so Dutch and French in the Belgian context. And this would seem to preclude at least a straightforward application of the Belgian linguistics reasoning to the scenario of Irish medium education in Northern Ireland. Given the context to which I alluded earlier, it seems to me that currently, as a matter of law, it would be difficult to construe Irish as a national language in this context. So again, then, the language rights claim being made in this case falls outside the scope of the rights provided under the Convention. Okay, so I'll turn now to the third and final strategy deployed in these cases, which is the various attempts to invoke domestic law. I'll start with the use of statutory duties. So, as I mentioned before, the Executive Committee of the Northern Ireland Assembly was placed under a statutory duty to adopt a strategy on the promotion of Irish. And on the basis of an application for judicial review brought by Conor na Gaeilge, the High Court declared that the committee was indeed in breach of this duty, having failed to adopt a strategy of this sort almost a decade later. The High Court underlined that the committee couldn't simply invoke the political sensitivities around the issue of Irish language promotion in order to evade its legal obligation. So this case is significant then. It demonstrates that the codification of a political commitment made originally under the St Andrews Agreement into domestic legislation created the scope for Irish language rights campaigners to successfully pursue their agenda within a legal forum. A successful challenge was made on the basis of the Department of Education's duty under Article 89 of the Education Order 1998 to encourage and facilitate Irish medium education. So the High Court held that this duty was not merely aspirational, but was intended to have concrete practical consequences, and it therefore found that the Department of Education had failed to give proper weight and consideration to its obligations under Article 89 when it refused to expand transport provision for what was then Northern Ireland's only Irish medium secondary school. So again, in this case, we can see that the codification of a political commitment, this time under the Belfast Good Friday Agreement, into domestic legislation created the scope, or as it were, the requisite legal opportunity structure to allow individuals to bring successful Irish language rights claims before the courts. Another similar challenge was made in the case of GC's application, and so here it was argued that the Education Minister's refusal to allow the Irish medium primary school to relocate to improved premises likewise was in breach of the Article 89 duty. And the High Court found in favour of the applicant, so it considered that the mere fact that this duty, the Article 89 duty, was mentioned in submissions to the Minister as part of the decision-making process was not sufficient to show that the duty had been discharged. This decision by the High Court was subsequently overturned by a 2-1 majority at the Court of Appeal. So there, the majority found that the fact that the Article 89 duty had been shown to be taken into account in some way during the decision-making process was sufficient to show that it had been discharged. I think there's some interesting stuff that comes out of this around the scope of the Article 89 duty, in particular in the dissenting opinion at the Court of Appeal. I'd be happy to talk about that more if that's of interest. But what's important here in terms of the argument in this paper is that the dispute, as it were, between the two courts is not about justiciability, but rather simply about the extent of the legal obligation entailed. Now, GC's application is also significant because the Minister's decision was challenged not only on the basis of this statutory duty, but also the more general standard common law ground of procedural fairness. So it was argued in particular that there had been insufficiency of inquiry because the Minister had failed to engage with material provided by an independent body that had been set up by the Department of Education to assist in discharging the Article 89 duty. Again, the High Court found in favour of the applicant, so it considered that the Minister should have had possession of all relevant information, and it therefore considered that the decision was unlawful also on the basis of procedural unfairness. Again, this decision was then subsequently overturned by the same 2-1 majority at the Court of Appeal, which considered that it was within the minister's discretion whether or not to take into account this additional information. Now, although this was ultimately unsuccessful from the perspective of the applicant, this case is nonetheless important in showing that executive decision-making with respect to Irish language rights issues, at least of this sort, is amenable to judicial review on the ground of procedural fairness. And this is particularly significant because the courts in Northern Ireland have found that political sensitivities around the issue of national security render certain kinds of decision-making with respect to counter-terrorism to be unamenable to review on the ground of procedural fairness. So GC's application then demonstrates that political sensitivities do not shield the executive when it comes to decision-making concerning Irish language rights issues on this basis. The potential use for these more kind of standard common law grounds was also demonstrated in the case concerning street signage. So here it was argued that Belfast City Council's policy of requiring a 2/3 majority of local residents to be expressly in favour of a particular proposal was Wednesbury unreasonable. In the end, the High Court decided that given the very contentious nature of multilingual signage in the Northern Ireland context, that it could not be unreasonable to require a very clear majority to be in favour. Nonetheless, again, while this was unsuccessful in this instance from the perspective of the applicants, this is important in illustrating that decision-making concerning Irish language rights issues is also amenable to review on this ground. Okay, so to briefly conclude then, we've seen that attempts to invoke the UK's international obligations under the European Charter for Regional or Minority Languages have been consistently thwarted by the principle of constitutional dualism. Attempts to invoke the European Convention on Human Rights have likewise had little traction, partly because of procedural issues concerning the standing requirements under Section 7 of the Human Rights Act, but more significantly because the matters at stake in these cases simply fall outside the substantive scope of human rights law. By contrast, we've seen that domestic statutory duties, powers and the common law do render language rights disputes amenable to judicial review, thus creating the requisite legal opportunity structure for successful language rights litigation. This is significant, of course, for Irish language rights litigation in Northern Ireland, but it also seems to me to have implications for language rights litigation elsewhere in the UK, notably with respect to Welsh in Wales and Gaelic in Scotland, where similar and often quite a bit more far-reaching statutory provision has also been made. Now, it's important not to overstate this conclusion, so we've also seen that litigation is very clearly constrained by the existing statutory framework. And this is most starkly illustrated by the issue of the use of Irish before the courts in Northern Ireland. So as we've seen, this is a matter that can really only be addressed through legislative reform. It's not something that can be affected via the courts. So while, and as I hope to have shown possible, litigation can only remain part of a broader effort to advance language rights in Northern Ireland. Okay, so I'll leave it there. Thanks very much for listening and look forward to any and all comments and questions.
Tim, thank you. That was excellent. I don't know where you've submitted the paper to, but I can think of at least 2 journals that would fight you for it. It's a really important paper. So there is a bit of time left for questions if anybody would like to ask them. I'm happy to either channel them through from the chat bar or to let people jump in if they want to raise their hand and put it to Tim orally. But maybe while people are thinking, I'll share some thoughts of my own. I mean, it's not my area at all, but one thing I do remember reading about Conran na Gaeilge, its challenge in particular around the statutory duty was the remedy granted by the court in the end, which was a declaration. And you know, I've asked students to read that case in a couple of tutorials in the past, and had interesting discussions about that litigation strategy. So I just wondered if you had any thoughts about what that says around the kind of purpose of these cases. So zoning in on the one successful way of getting a court involved and granting a remedy of sorts. Does it undermine the kind of utility of the process any where the only remedy granted is non-coercive? Because all that really does in reality is return the issue to the sphere, I suppose. So do you see there being added value anyway? And yeah, so maybe that's something to start you off, and then I'll think about other things.
Yeah, definitely. I think this is a really important issue that I probably glossed over somewhat. So yeah, thank you for raising it. No, I don't know how good a response I have to it, but yeah, I think, well, I guess it's an issue with judicial review generally that the outcomes of most of these cases are essentially redo the decision, you know, for most of them, and it could be that it's still, the outcome ends up being the same, but procedurally it's, you know, there's some procedural kind of amendments are made, and essentially, yeah, substantively it's the same result. So that's a very clear limitation, which I should perhaps also have mentioned in the conclusion, that it kind of only takes you so far. With the kind of declarative relief, particularly, I mean, it seems to me there's still a value to that insofar as it clarified that this was a legal obligation. This wasn't simply a political commitment that had been made, but that there was some significance, at least from the court's perspective, to it having been codified in legislation. It doesn't seem inappropriate to me, but this would be, others would be better placed to comment on it. It doesn't seem inappropriate to me that that matter should at least be partially resolved also within the political sphere. So I wouldn't particularly say that, you know, what's needed to resolve these kind of disputes is very kind of strong judicial review necessarily. It seems appropriate that there is a measure of political settlement that's also around even sort of relatively small scale disputes of that sort. So I don't know, that's some attempt at an answer anyway.
No, it's good. It's sparked another question, which is the effect of all these legal obligations, unless they're accompanied by something more coercive and that's kind of capable of leading to contempt effectively, are they not all essentially political levers? So I'm thinking here about what this says about the UK's relationship with international law generally at the moment. So, I mean, this point you're making is kind of something that can be situated in that broader conversation as well, I suppose, because if a government can sign up to all sorts of international law agreements, what good is it other than as a political lever at the domestic level? And I suppose to try and convert that into a question, what I would ask is, have you learned anything about other jurisdictions which are dualist that tells us anything about how good or bad the UK is in comparison to other states at complying with its international obligations, at least about minority language and giving effect to those commitments that exist at the international level?
Okay, yes, there's quite a lot in that. Yeah, I mean, I guess it's good. It's I guess the sort of initial issue is the kind of legal versus political constitutionalism issue more broadly, which is kind of part of, at least in terms of the role of judicial review in the UK. On the second point, it's maybe something I can say something slightly more useful about. I don't know if this is about so much the implementation of international obligations in this area. The main other jurisdiction I'm familiar with is Germany. That's the other one I'm working on for the PhD, and there are certainly striking differences there in that that's one jurisdiction where it's also a dualist system, but where the domestic law dealing with these issues is formulated in rights terms. You know, so it's the kind of counterexample for the, oh, this doesn't work in the UK because it's all about duties on authorities, and in Germany it's typically about members of this particular group having having the right to such and such. I'm not sure, but I haven't yet had the sense that that actually leads to more concrete right protection for those groups necessarily. My sense is that it's, I don't particularly have this feeling that the sort of legal mechanisms in the UK are a weakness compared to the setting there. I think another interesting comparator is Canada, maybe, which is obviously outside the Council of Europe setting, but where, again, where language rights are formulated in more expressly in rights terms. But I have less of a sense of how strong the protection there is relative to judicial review in the UK. Yeah.
That's a question to ask. Dahi, do you want to jump in?
Sure. Tim, thank you very much for a fascinating paper. And like Connor, I eagerly await seeing it published in a journal sometime soon. I wonder whether you might say something about the impact of the history you've told of litigating language rights in Northern Ireland for the drafting of legislation. I mean, as you know, this is a debate that Northern Ireland is going through and will do in coming months and years, as Wales and Scotland have before. And I wonder to what extent the prospect of new litigation arising out of new duties might have an influence on that drafting process. Given you are the expert on what has happened so far, can I invite you maybe to speculate as to what might happen next?
Okay, great. Hi, Dai. Yeah, okay. That puts me on the spot even more. Well, one thing maybe I can say on the kind of how things might develop in the future is that, as people are probably aware, there are some very interesting proposals that came up as part of the New Deal that was agreed, or the new settlement in January of this year between Sinn Féin and the DUP around language issues, some of which were symbolic. So as far as I remember, there was a suggestion, a proposal to have kind of, symbolic recognition of Irish in law, which is of course important, but less on the kind of practical, has perhaps fewer practical implications. Something that's interesting there is, to my knowledge, that there's no suggestion of introducing further duties, but that there'll be a mechanism with an Irish language commissioner, sort of analogous to the Welsh language commissioner in the Welsh setting, who might then develop standards for public authorities to follow in terms of the delivery of public services through the medium Irish. And that raises a whole new kind of potential mechanism by which challenges might be made. So people may be familiar, the role of the Welsh Language Commissioner in Wales is essentially to monitor compliance with Welsh language standards, which apply to public authorities in terms of policy making and service delivery and so on. And so individuals can then complain to the Commissioner when they feel that those standards are not being complied with. And I don't know precisely how that will work and how the proposals, and then of course whether the proposals will actually be implemented, but that creates a new kind of setting in which individuals could bring legal challenges of a sort within the Northern Ireland setting that's then completely from this sort of judicial review around statutory duties. Potentially more effective, I don't know, it's at least a more specialised body to deal with these things. But that would require, so I don't know enough really about how effective the Welsh Language Commissioner has been in Wales, but that then could make for an interesting comparison as well.
Very much, Tim. I see Bryce has his hand up as well. Bryce, do you want to ask your question?
Yes, thanks, Conor, and thanks, Tim, very much for your very interesting and clear talk. With reference to the New Deal, New Approach document that you and Dahi mentioned, if the 1737 Act was to be repealed as is intended, would that of itself, in your view, under the Charter and the Convention, entitle people who wanted to use Irish in the court to do so? Or would it first require Irish to be made a national language in Northern Ireland, as it is in Wales, for example?
Great, yeah, thanks very much for this question. Yeah, so as you say, the repeal of the 1737 Act is foreseen in this legislation. From my perspective, I would have thought further statutory provision would then be required along the lines of the relevant legislation in Wales. So I think the idea there is that while the right to use Welsh in court proceedings is a way of giving practical effect to the status, the official status of the Welsh language, the two are sort of separate. So in a sense that there's the kind of symbolic recognition of Wales as having that status, and then separate statutory provision that permits individuals to do that. So I guess my assumption would be that a similar kind of process would be required. But I'm happy to be told otherwise. Yeah.
No, thank you.
Well, I don't see any other hands up at the moment. So I suppose I think that might be a sign that it's time to wrap up in good time. But that was really interesting, and I hope that the few questions you got out of us were interesting and helpful. I suppose if anybody wants to follow up, they can find your details on the website of the European University Institute. Really appreciate you taking the time to give the talk, and I hope to see the paper very soon, although I know it has to go through peer review. So thank you once again. Thank you for coming, everybody. The details of further seminars in the Human Rights Centre series are always posted on our Twitter and Facebook pages. So, follow that and keep an eye if you find this enjoyable and interesting and you want to keep a hand in and stay involved. So thank you once again, and good afternoon, everybody.
Great, thanks everyone.